Rise. Court is now in session.
Please be seated. Thank you. Let's go back on the record. Again, let the record reflect that counsel for the state, counsel for the defense, the defendants are all present in the courtroom. You may call your next witness, please.
Judge, before we call the witness, can I get you to sign this order?
Okay.
Setting the case on it. Thank you, and all parties agreed to it.
Okay.
Thank you, Judge.
Counsel, your witness.
Thank you, Your Honor. Your Honor, the state calls Rocky Edwards.
Could you raise your right hand for me, please?
Do we
Oh, I'm
stand up
sorry. But yeah, you haven't testified.
He's new.
New.
Yes, Your Honor.
The break got me confused. You swear or affirm under the penalty of law that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth. I do. Thank you.
Mr. Edwards, we've asked you here today because you're a firearms examiner who was asked to do an independent analysis of ballistics evidence in this case. So can you please introduce yourself and tell us what you do for a living?
Yes, sir. My name is Rocky Edwards. I am a forensic firearm and tool mark examiner. I am currently employed with the Santa Ana Police Department and crime, and an application came across my desk looking for applicants for the Army Crime Lab, and I applied and was accepted. And so I went through 2 years of training with the United States Army Criminal Investigation Laboratory located at Fort Gillem, Georgia. During my training, I was trained extensively in firearm and tool mark identification. Also was sent to most of the major manufacturers of firearms, ammunition, and gunpowder in the United States, visited their factories, observed their manufacturing techniques. I was sent to the Southwestern Institute of Forensic Sciences in Dallas, Texas, and there I learned advanced techniques. And then from there I went to the Presidio of San Francisco, where I learned about firearms injuries, and from there I went to the Armed Forces Institute of Pathology in Washington, D.C., where I also learned more about firearms injuries. After completion of my training, which extensively dealt with functionality of firearms as far as examination of determinations, comparative analysis, microscopic analysis of bullets, cartridge cases, and also comparative analysis between firearms and those cartridge cases and bullets. So upon completion of my training, I was sent to Frankfurt, Germany, where I worked for the U.S. Army Crime Lab. I worked for the Army, basically did casework for the Army, Navy, Marine Corps, Air Force, and NATO forces, Britain and Canada. I also supported our troops toward the end of Desert Storm, also in Somalia and in Yugoslavia. I subsequently retired from the United States Army. I went to the LAPD, where I worked and I've for the association, as well as I've been a guest speaker at conferences in South Africa, Philippines, Montreal, and at numerous AFTI conference meetings. Marine Corps, Air Force, LA County, Orange County, Kern County, Ventura County, San Diego County, LA County, Arizona.
Sign for us, please.
Yes, sir. My curriculum background expertise.
Would having that assist the judge in understanding your qualifications to testify as an expert in this case?
Yes, sir.
And is that curriculum vitae in the same condition as when you provided it to us? With the exception of the holes punched in the side?
Yes, sir.
Your Honor, move State's Exhibit 49.
Any objection to 49?
Based on your earlier rulings, no, Your Honor.
No, Your Honor.
All right, 49 will be admitted without objection.
Your Honor, the State tenders Rocky Edwards as an expert witness in forensic firearms and ballistics identification.
Any objection, counsel?
No, Your Honor. No, Your Honor.
He'll be allowed to offer opinions in those areas.
Can you please explain to us the basic process of forensic firearms and ballistics identification, Mr. Edwards?
Yes, so the premise is that a firearm is considered a tool and that basically a firearms examination is a tool mark examination. When a harder surface touches a softer surface, it transfers characteristics from the harder surface to the softer surface and leaves unique markings that are can be microscopically compared and identified back to the particular source. And that's the basis for a firearm tool mark identification.
So, when you're attempting to make a firearm identification, what is essentially the basic technique that you use?
Well, if I have a firearm and I have cartridge cases and bullets, well, what I will do is I will examine the firearm for functionality. First of all, to ensure that it's safe for me to fire and to ensure that everything is operating as designed by the manufacturers. Make sure the safeties work properly, trigger pull's proper. From there, I will actually test fire the rifle and get exemplars. And then as far as the evidence is concerned, I'll do worksheets on the evidence, examine that, and determine how many firearms fired those particular cartridge cases. If there's multiple cartridge cases, then I'll look to see how many guns were involved. I mean, sometimes there can be up to 100 cartridge cases in a shooting, and you just got to figure out how many guns were used in that amount of that cartridge cases from that scene. Same with the bullets. Then I do type and caliber of the bullets to determine what kind of firearm fired those bullets. And then from there, I'll take the test fires and I'll examine the test fires to each other. And what I'm looking for between the test fires from the firearm is to determine if they're identifiable. There's 3 different characteristics I look for. There's class.
Let me stop you there. When you're looking for these characteristics, is there a method or a tool that you use to do that?
Yes, sir. There's a comparison microscope.
Tell us about that, please.
Well, a comparison microscope's been around since 1927. Calvin Goddard, who's considered the father of firearms identification, brought in John Fisher and Philip Gravel, and they brought in from the textile industry the comparison microscope. So since about 1927, that scope's been in use. Of course, it's way improved now since those days. The optics are amazing. The way the scope operates is high-tech. And so that's my primary piece, my tool. That's my main tool that I use. And so what I'll do is I'll look at objects side by side on the microscope, looking at the agreement or disagreement between items of evidence that I'm examining. So without the comparison microscope, then I wouldn't be able to do that examination.
Okay, so you explained to us the tool that you use, so tell us essentially what kinds of things you're looking for when you're making an identification.
Well, first of all, I'm looking at 3 different kind of characteristics. I'm looking at class characteristics, subclass, and individual. Class characteristics are those things that are determined by the manufacturer at the time that the firearm was built, such as, is it a semi-automatic versus revolver, what caliber it is, how many landing grooves it has in the barrel, which is 5 or 6, 4, whatever the manufacturer decides, and the direction of twist, whether it's left or right. So those are the kind of what considered class characteristics.
If I may, Mr. Edwards, what's a land and groove? What are lands and grooves in a barrel?
Well, if you ever look down the barrel of a firearm, you'll see a spiraling in that barrel, and there's like a valley and then there's a peak. And what that does is when the bullet engages that, it imparts a spin to it, giving it a gyroscopic spin, stabilizing that bullet toward its target. So that's why they put landing grooves inside the barrel.
Okay. So you were describing to us that you're looking for characteristics consistent with the lands and grooves in the barrel.
Yes.
So what kind of characteristics are you looking for?
I'm looking, if I'm looking for class characteristics, I want to make sure that the class characteristics match those of the evidence, because if I have a bullet that's 6 right and the bullet that I'm looking at is 5 right, then obviously it's not the gun, and that's the end of the case.
And so just so I'm understanding, so we're all clear here, if a firearm fires a bullet and there are 6 cuts that make the rifling that helps stabilize that bullet, would it leave 6 marks that you'd expect to see on that bullet?
Yes, sir. What happens is,
Objection leading, Your Honor.
Sustained.
It's foundational, Your Honor, just explaining the process.
Well, I don't necessarily agree with your foundational, but I'd ask you to rephrase the question if you want the answer this time.
If a barrel of a rifle has 6 lands on it, how many landmarks would you expect to see on the bullet that fired, that barrel fired?
provided that the rifling is in good shape and that it's not worn, I would expect to see 6 landing grooves in it.
And if you had a different firearm that had 5 lands on it, how many would you expect to see on a bullet that fired that one?
Provided the condition of the barrel was in, good condition, then I would expect to see 5.
So when you're talking about the primary characteristics, just the agreement of the lands, is that essentially what you're talking about, making sure the numbers line up?
Well, I'm going to make sure that the count's right for class characteristics, because I don't want to go to the trouble of putting stuff on the microscope if it's obviously not the right gun to begin with, so, or right firearm.
And can you tell that just by looking at the bullet?
Sure.
Okay. In addition to the number of landmarks or groove marks, what else do you look for on these bullets?
Well, caliber, make sure it's the right caliber. And also the measurements of the landing grooves are important. If I look at a bullet that has a certain measurement and the other from the rifle is obviously not the same measurement, that's easily identifiable as well.
Measurements of what?
The landing grooves
On the bullet?
on the barrel.
Oh, okay.
And it's transferred. What happens when the bullet goes down the barrel, it creates a negative impression on the bullet. Remember when I talk about the firearm being a tool, the bullet is softer than the metal in the rifle, so therefore the characteristics of that barrel are transferred to the softer object, which is the bullet.
Okay. And what else do you look for?
Well, from there I go into the subclass and also look at the individual characteristics.
And how do you attempt to make those kinds of comparisons?
Subclass characteristics are gross characteristics that normally are on the groove impression of a firearm. And what happens is they're going to be gross marks that carry the length of the bullet. And when I do an identification, even though I take into consideration the groove impressions, I won't make an identification solely on the groove because of that reason. So I've got to have characteristics, individual characteristics within the land impressions of the bullet in order, if I see sufficient agreement there, then I'll make that identification.
Is there a magic number of points of agreement that you typically have to find in order to make an identification?
No, sir.
What were you asked to do in this case?
I was asked to compare the test fires from 2 rifles and also determine if one of those rifles fired the bullet that was submitted for comparison, as well as to look at a bullet fragment.
At some point, did you, in doing that, receive evidence from a man named Detective Jeff Stone?
Yes, sir.
I'm handing you what have been previously admitted as States Exhibit 54 and 55.
Your Honor, can I just ask a question on that? Has 54 and 55 been admitted? I think they were both identified, but I remember one of them being admitted. I didn't hear the other one being moved to be admitted.
Ruth, do you know if they were admitted? I have 50,
I have 55A and I'm sorry, what was
I have 54 being admitted.
it? I have 54 in.
I have 54A being admitted. I don't have 55.
Yeah, I don't have 55 either on mine, Your Honor. I would object to testifying to anything regarding 55 then.
I lay the foundation, Your Honor.
Go ahead.
I'm handing you what's been previously marked for identification purposes as States Exhibit 55. You ever seen those before?
Yes, sir.
What are they?
There were fired cartridge cases and bullets that I was asked to examine.
Are the same or substantially same condition as when you received them and examined them?
Yes, sir, they appear so.
Move 55, Your Honor.
Any objection?
Can I board down the witness then a little bit? Just
Yes.
a couple of questions. You didn't put any of the markings on the outside of that, did you?
On the envelope, yes, sir.
On the envelope you did?
Yes, sir.
Okay. Which ones did you put on?
Red tape with an RE on
So you did that while it was in your possession?
it. Yes, sir.
Okay. So when was that specific, when were they in your possession?
2 occasions.
2 separate occasions?
Yes, sir.
Okay. And that was the envelope you used?
Yes, sir.
Okay. I don't have any objections then, Your Honor.
No objections, Your Honor.
All right, 55 will be admitted.
So now I'm handing you what have been previously admitted as States Exhibit 55 and 54. We've already established 55. What were 54?
54 is another clear plastic container of cartridge cases and fired bullets marked with my initials, red tape, showing when I was in possession of the envelope.
Handing you what's been previously admitted as 53A. What's that?
Yes, sir. This is a bullet fragment that I examined. It's got my initials on the red tape as well when I sealed it.
traveled in beauty with the Navajo Nation.
Tell us about that process.
Well, I examined the bullets only. In this case, I didn't examine any cartridge cases. I looked at the test fires from firearm 1, and then I looked at, which is marked on the envelope. Then I looked at the test fires from the envelope of firearm 2. And what I'm doing is I'm looking at the test fires to see if they are individual, if I can see sufficient individual characteristics to where I can identify them to each other from firearm 1 and firearm 2. And the reason for that is if there's not sufficient characteristics from those test fires, then there's no use for me to even move forward in attempting a further comparison. So what I did was I looked at firearm 1 and did my comparison of the test fires to each other, found sufficient agreement. Then I examined the bullets from firearm 2 and did sufficient agreement, in terms of sufficient agreement. And then at that point, I started doing a microscopic comparison between firearm 1 and firearm 2 to the autopsy bullet.
Now, did you do that with all the test fires or just some of the test fires?
No, I looked at all of them.
When you're looking at those envelopes there, how many kinds of ammunition does it appear the test fires were done with?
There's 2 different brands of ammunition in both of these packets. One is Federal and one is Speer. And the bullets have class characteristics showing me which ones are the Speer versus the Federal. So I looked at both packets, and then I did a examination of the autopsy bullet to the 2 test fires.
Okay, when you were making that, doing that examination, did you take pictures of that process?
Yes, sir.
Explain to us how you do that.
Well, back in the old days, we used to use Polaroid cameras. Nowadays, it's much more sophisticated. We have digital cameras now mounted on top of microscopes. And so as I do the comparative analysis, if I make an identification, then I'll start identifying and photographing the agreement on where I'm seeing the identification. So the first step in doing this is I look for what we call a starting point. Starting point or characteristics that stand out to where I look for the same agreement between the test fires. And once I find that starting point, much like a combination, then that if there's sufficient agreement for identification, I'll find other agreement on land impressions and groove impressions from that point on around the circumference of the buried surface of that bullet.
So during that examination process that you took pictures of, did you ultimately come to a conclusion?
Yes, sir.
And what was your conclusion at that point in all of this process?
My conclusion was that the autopsy bullet had been fired in and through the same firearm that fired the bullets marked in the envelope firearm 1.
And so is it fair to say you were able to make a match between the autopsy bullet and the test fires from firearm 1?
I made a positive comparison. Yes, sir.
Did you decide you wanted to take any other steps after that?
Yes, sir. I found that in cases like this where other agencies have looked at this, I felt like it was important to be able to show using 3D virtual comparison microscope. It's high definition to show a better view of where the agreement is on the bullets that I was examining. So I photographed on June 3rd the comparison of firearm 1 to the autopsy bullet. I wanted to see firearm 2 and firearm 1 under the 3D. So it's like SLR camera versus a digital camera. It's just another way of looking at it. The 3D gives me an ability to look at things clearer. It's always in focus, and it functions very similar to comparison microscope. So that was the reason why I requested this to be done.
Did you also ask for that because it would be helpful to, well, who else would that have been helpful to, having those kind of specialized images taken?
Well, 2 things. I mean, it's not the first time that I've used 3D. It's used as a way to show another agency or show somebody else where I'm looking at in a clear, concise way. It's also a clear way to show the court where the comparison is, and comparison as far as what I'm looking at on the conventional microscope. The conventional microscope photographs are 2D, the 3D, HD 3D, or 3D look at the bearing surface of the bullet. It gives a better idea of how and what I'm looking at on the comparison microscope. If you're looking on the comparison microscope and I take a photograph on that, it'd be the same as if you went to the Grand Canyon, took a picture of the Grand Canyon and come back and said, hey, look at this, look how magnificent the Grand Canyon is. It's just not the same effect. So in a lot of ways, the 3D kind of brings in a little bit more of effect of what it is when we're looking on a comparison microscope.
Are there also benefits to the 3D images regarding focus?
Yeah, it's always in focus. It's always, it helps to fight glare. One of the issues I have on comparison microscopes, it's not just me, it's an issue with other examiners have as far as with LED lighting, fighting glare. This just helps to provide another way of looking at the evidence. It's a supplemental tool. Sometimes this tool is used to help look for areas of possible identification that I may be missing on the actual evidence. In previous cases I've worked, the 3D has assisted in that way. In other ways, the 3D, in this case, is just used as another way to look at the areas of comparison that I'm showing as far as to show you where I saw the agreement.
Did you need to use HD 3D imaging in this case to make
No,
the
sir,
comparison?
I did not.
So in order to get HD 3D imaging for this case, what did you have done?
Well, I asked Detective Stone and I asked attorneys to have it scanned in Montreal. There's times where I've flown to Montreal and was present during when these scans are done. There's also ways of doing what we call double casting, where we actually cast the evidence. The evidence is flown to Montreal, and they scan that, and it's just as precise as the actual evidence itself. And in this case, Detective Stone actually flew the evidence to Montreal and had it entered into the HD 3D bullet track system.
Did you ultimately get high definition 3D images of these bolts that were scanned?
Yes, sir, I did.
What did you do with them?
I have a simulator that's provided to me by Forensic Technology, and it's like having a 3D comparison microscope. The items that I'm looking at as far as the test fires, I can manipulate them just like I can on the comparison microscope. They rotate, they move back and forth, they can zoom in, zoom out, and so it gives me another view of what I'm looking at on the microscope. I already had the identification identified, but what I was interested in on the 3D was to find the starting point. If there was a starting point on firearm 1 that was on the HD 3D, and if there's anything similar on the firearm 2, that would be reproducing like that. And I didn't see it on a conventional microscope, but I wanted to make sure. So when I went through this, I was looking at the HD 3D, went to the starting point. From that point on, started photographing, capturing the images on where I saw agreement on the HD 3D as it relates to firearms 1.
At some point, did you create a presentation for the court of original photographs of your first match and from the comparison microscope and these advanced images?
What I did was I used a combination of photographs from June 6th, and I believe it was June 24th on the conventional microscope, because I looked at them both times. I didn't just look at them one time, I looked at them again. Also looked at the HD 3D, and what I did, it was put together a PowerPoint presentation to show what I saw.
And did you provide that PowerPoint presentation to us?
Yes, sir, I did.
And the images in that presentation fairly and accurately depict the various stages of your examination as you were carrying it out those days.
The closest possible way that I can show the court what I saw.
Your Honor, move the admission of State's Exhibit 51.
Any objection?
No, Your Honor. No, Your Honor.
51, you said?
Yes, Your Honor.
That would be admitted.
Okay. And Judge, I think we're going to have to, if we may, switch over to the podium presentation so that we can show this. And Mr. Edwards, for your benefit, if you need to, you can actually touch that screen to your right, and it will make marks on there. And you can clear it by touching the screen in the bottom left corner.
So I just touch the bottom left corner and it goes away?
That'll clear it, and once it's up there, you can touch on the screen to make marks if you need.
Okay.
Is that podium VGA?
I believe so, Your Honor.
It's whatever you're plugged into, Ken.
I'm HDMI. Is there a different
Yeah.
switch?
Yeah, there is.
Okay.
Okay.
Oh, there we are. All right. So, why don't you tell me when you would like me to advance slides or what you would like me to click through, and let's explain to the court what this presentation is.
Okay, basically, what I've done is I've taken a series of photographs of the circumference of the autopsy bullet. And then what I did was did a combination 3D versus the 2D imagery and show the court where I saw in the conventional microscope versus the HD 3D, and just gives as clear a presentation to the court as possible of what I saw and the work that I did on this case. So you can advance to the next slide, please. This is a 3D image captured from the simulator. It shows the bearing surface of the Firearm 1 test fires. There's 2 test fires I used. Test fire 1, test fire 2 is just what I designate for the purpose of this presentation under Firearm 1. So remember when I talked about how it's important to be able to find a starting point. So that's what I'm doing. I'm looking for a starting point. So this shows you in 3D what the starting point looks like.
If I may, Mr. Edwards, in this 3D image, there's a straight line down the middle, a thin line. Why is that line there?
Because that shows you, that's the same way with the comparison microscope. There's a divider in the comparison microscope, just like there is in this virtual comparison microscope. And what that does, left side is test fire 1, but right side is test fire 2.
So is a fair summary of that you're taking 2 pictures and essentially putting them next to each other to see where they line up?
Jeff's leading.
Sustained.
What are you doing with those 2 pictures as far as this line is
Taking 2
concerned?
objects side by side to look for the agreement.
All right. What would you like me to do next, sir?
Go to the next slide. Okay, this is test fire 1, test fire 2 from firearm 1 to the autopsy bullet on the starting point. So this is where I indicated that I found the starting point, and so this is where the combination starts coming together to start going around the bullet, looking for agreement. So this is where it starts. Now, on the left side of this image, you're going to see the flattened images of the bullets, and they're flattened out. And that's on the simulator. This is how I manipulate or rotate each side of what I'm looking at. Up at the top, you're going to see where it says green test FA1, test fire 1, FA1, test fire 2, red, FA2, test fire 1, FA2, test fire 2, and then the evidence, which is the autopsy bullet.
And just so everyone can be clear, can you, with your fingers, kind of trace the part you were just describing up there on that monitor?
I'm not very good at drawing.
That's all right.
Okay, I'm talking about this area right in here.
Okay. Why are some green and some red?
Red means it's not on the screen. They're shut off.
And
Once they go green, that means they're on.
Okay. So, in light of the fact that FA1, test fire 1, FA1, test fire 2, and evidence are lit up, what do we know about the pictures we're looking at?
Well, what I'm doing is I'm looking at, if you look down here, that's what I was looking for from a starting point. So I've got a starting point here, and I got one here, and I got one here. And so that's representative here.
All right.
So that's where I began my comparative analysis of this in 3D. So now I already had seen this on the conventional microscope, so I already knew that this corresponded with what I saw on my initial examination of the comparison microscope. So you go to the next slide, please.
And if you want to clear that, you can just tap in the bottom left of the screen, Mr. Edwards. All right, what are we looking at here?
Okay, what I did is Like I said, I took the photographs around the circumference of the bullet. And so this is where I found my starting point. I designate that as land impression number 1. And there again, you see the characteristics here as my starting point. The orange triangles represent, on the PowerPoint, if you click on it, it takes you to the point of photograph that's taken or captured on 3D. Blue is on the conventional microscope. So we've already seen the top 2 on land impression 1. The first 2 slides of the presentation, we've already seen those. If you go to the blue and click on that, this is the conventional microscope of the same area that I showed you on the 3D. This is my starting point, and this is through the comparison microscope.
Okay, so do you want me to go back, or how would you like me to
Yeah, go
proceed?
down and click on the bottom gray arrow there. Okay.
Next slide.
Yeah, just click on the main screen. It'll take you to the next one. Okay. Now, you don't see any orange or any blue there because I didn't see anything that was worth taking a photograph of, so there's nothing there. So I didn't photograph it. Go ahead and click on the screen again, the main screen. Now we're on land impression 2. Up in the right-hand corner up here, you're going to see where I marked it as 2. That designates land impression number 2, which is as the bullet is rotating upward. We're now to the next land impression. Click on the orange, the 3D, please. Here we have agreement in here. We have agreement down through here. We have agreement through here. And so I'm starting to pick up some agreement on the land impression right along the edge of the groove impression. Also, there's agreement here. Agreement here. It's hard to see on this, but and then right here. So we've got agreement in this area here that's starting to show on the groove impression. So I've got agreement on land impression 1. Now I'm looking at land impression 2. I've got agreement showing up here and on the groove impression between 2 and 3.
And based on the colored bars to the left, what 2 images are we looking at this point?
Say that again.
Based on the colored bars to the left, the green bars, what 2 images are we looking at?
Firearm test fire 1 and evidence of autopsy.
Next slide.
Yeah, go ahead and hit the arrow. And let's go to the conventional microscope, the blue. Here again, if you remember the 3D where I showed you on the groove impression, there's like an area of agreement. It's going to be this area right here. And then the area below that, this is what it looks like on the comparison microscope. There's agreement there. I'm sorry. It's kind of covered that. So that's agreement there. So now I'm going around the circumference of the bullet. I'm looking at individual characteristics that are starting to show up on the bullet as I go around it. All right, so go ahead and click on that one, I guess. This is another area of agreement. Now this area is forward of where the 3D scans are. So this is up forward of that, but I saw agreement and I went and photographed it as well. So this is agreement and land impression number 2. Go ahead and click on the main screen. We already saw agreement between 2 and 3 from the previous slide, so I didn't put anything else on that one. Go to the next one, please. This is land impression number 3, as I'm going around the circumference of the bullet. If you would, on the left, 3Ds. We've got agreement up here along this area here, and also in this area here on the edges. So as I'm going around this, things are starting to show agreement as well as I'm going around the circumference of the bullet. Okay, click on the arrow.
If I may, based on the colors, the 2 green, what 2 bullet pictures are we looking at this point?
I'm looking at firearm number 1, test fire 2 to evidence.
So this is different than firearm 1, test fire 1, correct?
It's actually leading.
Is this different from the pictures we were looking at before?
Yes, it is. Before it was firearm 1, test fire 1, and I'm switching between test fire 1, firearm 1, and test fire 2 on firearm 1.
And as you're switching between the two test fires comparing to the autopsy bullet, are you seeing any kinds of agreement?
Yes, as I'm going through it. This is another photograph here. It shows 3D along the edge here. There's agreement right here on this ridge, as well as some agreement right here along this area here. So that's where I'm looking at on land impression number 3. And this is from test fire 2 of firearm 1 to the autopsy bullet. If you go to conventional microscope, here again, you'll see agreement between them right in here. And there's some agreement up in here. This is another angle of lighting showing the agreement on land impression number 3. This is between 3 and 4. So remember, this is going around. If you're looking at the base of the bullet, we're actually rotating in a clockwise motion. If you would click on the top left for 3D, here we are, we're getting into some gross characteristics that are showing up on the groove impression. There's a lot of agreement between here and this area here. And you also, if you see some agreement up through here as well. And you'll also notice that up here, you got agreement up here as well and land impression above that. So everything is flowing as far as showing the agreement on the buried surface of that bullet between test fire 2, firearm 1, and the evidence autopsy bullet. This is another angle, different angle looking at this. This shows the groove impression, and you'll see the agreement through here as well. So this is all part of this coming together. And up here, you'll see agreement on the groove impression. Up here, you'll see the same agreement that we just talked about on land impression number 3. So we're looking at this 3D, we're looking at straight on at the groove impression, and as we look up over the bearing surface, it's starting to curve on the bearing surface of that bullet. Now this is through the conventional microscope. This shows you the agreement on the groove impression, those gross characteristics we saw on 3D. That's this area right here. If you would click on the 3D. Here again we have agreement all through the bottom portion of this land impression, all up through here. That's the area of agreement that I'm looking at. This is from firearm 1, test fire 2 to the autopsy bullet. This is test fire 1, firearm 1, test fire 2, firearm 2, and this is the autopsy land impression number 4. And you'll see all these characteristics right in here. This is unique here. This is unique. This is unique. And so this is a really strong area as far as area of comparison is concerned. It's land impressions and a lot of agreement. Okay, go to the main, back to the arrow down here. And if you would click on the blue one. This is that same area we just looked at. We saw it kind of flowing upward. This is between firearm 1. This is marked test fire 3, so this is going to be on my screen test fire 1. Because I marked on the base of the bullet, I think 3, and the other one was 4. So this is 3, this is going to be on 1, and this is the autopsy bullet on the right-hand side. And this is the areas of agreement that I'm showing. And so you can see clearly the distinguishable differences between 3D and the conventional microscope. You would go gray area. Click on the main screen.
I'm sorry, it's
between groove impression 4 and 5, I didn't see anything worthy of photographing there, so go ahead and click the next one. This is on land impression number 5. This is the 3D imagery here. We've got agreement here. We've got some agreement up in this area right here. If you would click on the gray one there. And next one, same photograph for the most part, just a little bit different angle. This shows you the area as well. This is between firearm 1, test fire 1, and the evidence. This is through the conventional microscope. You can see some of the focus issues we have on the scope. It's coming in really well as far as seeing where the agreement is. This agreement here. I'm actually getting some agreement down through here in this area here. So this is land impression number 5. And you would go back to the arrow down there. And then another 3D. Oh, that's right. No, we're good. This is the conventional microscope, more magnification on it. Here again, you see the agreement here and through here. And there's some agreement up through here.
.3D first? Would you like 3D first, Mr. Edwards?
Yeah, please.
Okay.
There's some agreement on the groove impression right through here. And down in here. Conventional. This is agreement through here, through here, here, through here. So this, where I'm seeing agreement on this groove impression between 5 and 6. And if we would go to main screen. And now we're on land impression number 6. If you would go to 3D, left side. Here we have considerable agreement on the number 6 land impression through here. And on the next one, through here. This is pointing firearm 1, test fire 2, and the evidence. On land impression number 6. And if you would click on the orange arrow. And this is that area here between test fire 1 and the autopsy bullet on land impression number 6. Between 6 and 1, I didn't see anything that was sufficient for me to ID. So, and that's how I reached my conclusion, was the cumulative agreement, the spatial agreement, agreement that I've seen all the way around the circumference of the bullet. The
Were you at the
agreement
end of
that
it?
I saw was on 6 land impressions I saw agreement, and on 2 groove impressions I saw agreement. That cumulative agreement around the circumference of the bullet that's what I based my opinion on, that it was fired by firearm number 1.
When making these kind of comparisons, how many points of agreement do you need to be able to call a match?
There's not a set point system as far as points. We have consecutively matching striations. Some examiners go by that. But it's a cumulative agreement where I'm looking at something and the likelihood another firearm could reproduce this amount of agreement. I have to make that decision whether or not it exceeds that agreement between what we call known non-matches. In the universe of this shooting, there's 2 firearms in question. And so I examined both bullets. Both were identifiable with each other. Both were distinctively different microscopically. And the firearm 1 is the one where I was able to make the identification.
How many overall points of comparison and match did you end up finding between these test fires?
6 land impressions, 2 groove impressions.
So based on that information, in your expert opinion, which firearm fired the bullet recovered from the autopsy of James Boyd?
Firearm 1.
Your Honor, may we have the podium switched over to the Elmo, please? Mr. Edwards, I'm showing you what's been previously admitted, identified by Detective Nate Render as the Noveski firearm taken from defendant Dominic Perez, identified as firearm 1. It's hard to see, but on this Post-it note in this picture, there's an F, and what is that number my pen is pointing to on that Post-it number?
All I see is a -1.
Okay.
I don't know what the other symbol is. Can't see it clearly.
Pass the witness, Your Honor.
I don't have any questions, Your Honor.
I don't either, Your Honor.
May this witness be excused from the case now?
He may, Your Honor.
Any objection? Okay. Thank you, sir. You may step down.
Thank you, sir. Here you have Mr. Dye.
Just leave it right there, okay?
Your Honor, the state rests its case, and that's the last piece of evidence we're going to put on today.
Okay. Defense, any motions?
Yes, Your Honor, would the court entertain a motion to dismiss an argument on that motion at this
Go ahead.
point? Your Honor, at this point, Defendant Perez respectfully moves the court to dismiss the charges brought in the amended information filed against him on June 22nd, 2015. We know that the law governing justifiable homicide by a police officer, as set forth in NMSA 30-2-6 and the UJI 14-5173, is that deadly force is authorized if a reasonable officer in the defendant's position would have probable cause to believe that the decedent posed a threat of death or great bodily harm to another person. We also know from State v. Mantelli that the reasonableness of an officer's actions must be evaluated from that officer's perspective. We also know that if any evidence supports Officer Perez's contention that his actions were legally justified, that the burden shifts to the state to demonstrate that his actions were legally unjustified. The state has now completed its case, and it has not presented sufficient evidence to meet its burden to demonstrate to a reasonable probability that Officer Perez lacked legal justification for his actions. Now, the court has before it evidence which has not been disputed by anyone who testified in the state's case. It has evidence that, prior to Officer Perez's arrival on the scene, Mr. Boyd drew 2 knives from his pockets and threatened to kill 2 open-space police officers, thereby committing the felony crime of aggravated assault with a deadly weapon on a peace officer. We know that the court has evidence before it, undisputed, that shortly prior to the time he was shot, Mr. Boyd shouted words to the effect that it would be legal for him to kill the police officers before him. It has evidence before it that just prior to the time Officer Perez shot at Mr. Boyd, other officers had unsuccessfully launched a flashbang distraction device, fired shotgun taser rounds, and deployed a police service dog, all in a coordinated effort to effect an arrest on Mr. Boyd using less lethal means. The court has evidence before it, undisputed, that just prior to the time he was shot, Mr. Boyd drew out 2 knives and held them up while directly facing the police officers. And finally, the court has evidence before it, undisputed, that the officer nearest to Mr. Boyd at the time he drew his knives, Officer Scott Weimer-Skirch, was less than 10 feet away from Mr. Boyd and on ground more than 3 feet lower than that occupied by Mr. Boyd, who towered above him. Officer Weimer-Skirch was not carrying a firearm at the time. What we don't have, now that the state has completed its case, is evidence that the shooting of James Boyd by Officer Dominique Perez was legally unjustified under these undisputed circumstances. What we have instead is arguments that are contrary to the law and to the undisputed facts. Of course, arguments of counsel are not evidence and can't be used to create asserted facts. Instead, the arguments raised by the state, especially those about issues such as whether other officers responded in an ideal fashion, or whether, in hindsight, the shooting of Mr. Boyd could conceivably have been avoided or prevented if other policies had been in place or other tactics used prior to the time Mr. Boyd posed a deadly threat, are an attempt to distract from the only question that is relevant as a matter of law to Officer Perez, the reasonableness of his belief at the time he shot at Mr. Boyd that Mr. Boyd posed a threat of death or serious bodily injury to another. For instance, the state claims in its trial brief, quote, "At the preliminary hearing, the court's task will be to determine whether, despite any evidence of justification presented by the defendants, there is probable cause to support the state's contention that the defendants were the aggressors in the altercation." Now, that task is easy to dispose of with respect to Officer Perez. The state has introduced no evidence whatsoever to demonstrate that Officer Perez himself was an aggressor or an instigator of the altercation in any way. Instead, the evidence has been undisputed that Officer Perez simply reported to the location he was sent to station himself as lethal cover, and that he was not directly involved in the attempted arrest. No one testified otherwise in the state's case. Nor can the state take the focus away from whether Officer Perez's actions were objectively reasonable based on his perspective at the time of the incident by trying to point to the actions of others. No case law in New Mexico holds that the defense of another or justifiable homicide by a police officer is precluded by the aggression of someone other than the defendant. That would put the defendant in a position of having to make a split-second decision about whether someone in mortal danger could possibly be considered an aggressor and therefore eligible to be saved only at a defendant's criminal peril. That is not the sort of split-second decision that's called for by the law. The state has not cited any cases in its trial brief which it holds out as setting forth its view of the law that should govern this case, which speak to starting the fight by someone other than a defendant or in any context other than strict self-defense, not defense of another, not justifiable homicide by a police officer. The state cites State v. Chavez for the proposition that the rule is well established in this jurisdiction that a defendant who provokes an encounter, as a result of which he finds it necessary to use deadly force to defend himself, is guilty of an unlawful homicide and cannot avail himself of the claim that he was acting in self-defense. It cites Territory v. Clark for the proposition that defendants cannot avail themselves of the doctrine of necessary self-defense if the necessity of that defense was brought on by themselves or provoked by the defendant's own deliberate or malicious acts. Finally, the state cites Territory versus Gonzalez for the proposition that a defendant charged with murder cannot avail himself of the claim of necessary self-defense if the necessity for such a defense was brought on by his own deliberate wrongful act. These cases are simply inapplicable to the circumstances before the court. Moreover, the uniform jury instructions that speaks to the effect of being an aggressor, also cited by the state in its trial brief, that's UJI 5191 is explicitly limited to self-defense. There's no such instruction related to defense of another or justifiable homicide by a police officer. In fact, the committee commentary for UJI 14-5172, which governs defense of another, specifically notes that the New Mexico Supreme Court in State versus Maestas, 63 NM 67, declined to adopt the precept that a person using deadly force in defense of another stands in the shoes of the person defended. Instead, the committee recognized that a defendant is to be judged only on the basis of his own perception of the danger under the circumstances. Therefore, even if other officers could be considered aggressors in this situation, that cannot limit Officer Perez's ability to utilize these defenses based on his reasonable perception of danger at the time. Now, the state argues that in considering the objective reasonableness of Officer Perez's use of force, the finder of fact must consider all of the events leading up to the decedent's threat of force. However, the two cases cited by the state for this proposition actually hold the opposite and demonstrate exactly why this evidence is not relevant to Officer Perez's decision to use deadly force. The state cites Allen versus Muskogee, Oklahoma, and Sevier versus City of Lawrence, Kansas. These cases actually state that the reasonableness of a defendant's action depends on whether other officers appeared in danger at the precise moment that force is used, and on whether the defendant's own conduct immediately connected to the suspect's threat of force was reckless, thereby unreasonably creating the use of force. The cases instruct that if events preceding the need to use force are not the acts of the defendant, or if they're attenuated by time or intervening events, or if they're merely negligent rather than reckless, they are not to be considered. Therefore, the reasonableness of the acts of the open space officers, which we've heard so much about these past 3 days, almost 3 hours before Officer Perez even arrived on scene, are legally irrelevant to the reasonableness of his actions based on his perceptions at the time he used deadly force. The state also argues that other officers created the need to use deadly force by moving in to arrest Mr. Boyd, resulting in his pulling out knives in self-defense. As we've already discussed, if the defendant actions are taken into consideration under the creation of the danger doctrine, it's only the defendant's actions that can be taken into consideration under the creation of the danger doctrine. But even if the actions of his fellow officers are taken into account in evaluating the reasonableness of Officer Perez's actions, those officers cannot be said to have been the aggressors as a legal matter under the undisputed testimony. It's undisputed that Mr. Boyd had drawn 2 knives from his pockets and threatened to kill the 2 open space police officers, thereby committing the felony crime of aggravated assault on a police officer. Under State v. Alaniz, 1961 NMSC 140, officers not only had the right, but the duty to arrest Mr. Boyd. That case recognizes that with such a duty comes the right to use the necessary force to overcome resistance in making the arrest. And along the same lines, it is well established that the Fourth Amendment does not require an officer to use the least or even a less forceful alternative when effectuating an arrest, so long as the force used is reasonable. That comes, for instance, from Medina v. Cram, 252 Fed 3rd, 1124. For these reasons, State v. Mantelli, which sets the standard in this state for evaluating whether a homicide by a police officer is justified, recognizes that unlike private citizens who may not be the aggressor and then claim self-defense, police officers sometimes have a legal duty to be aggressors in the course of fulfilling their duties to the public. It therefore held that an instruction that a self-defense claim is unavailable to an aggressor would create a fatal inconsistency as applied to the privilege of police officers. The wisdom of Mantelli is that it recognizes that because police officers are obligated to make arrests and don't always have the luxury of avoiding a danger if a suspect doesn't comply with their commands, they're provided with a wider scope of privilege than the general public with respect to the use of deadly force. It recognizes that this scope, this wider scope, is incorporated directly into the statute on justifiable homicide by a police officer, NMSA 30-2-6. Therefore, the state's argument that Officer Perez's claim of justifiable homicide by a peace officer is not worthy if it was necessitated by Mr. Boyd's reaction to the effectuation of a lawful arrest is not supported by the law. Now, the state also argues that just prior to being shot, Mr. Boyd drew his knives in self-defense as a result of the other officer's actions in attempting to effectuate his arrest. Of course, the law is well established that self-defense against a peace officer is sharply limited because officers are permitted to use the force necessary to effectuate an arrest. This is because when a police officer uses justified force to effect an arrest, the arrestee has no right of self-defense. That comes from State v. Denzel B., 2008, NMCA 118. Now, in this case, the force was being used to effectuate the lawful felony arrest of a non-compliant Mr. Boyd. And finally, the state has argued that Mr. Boyd had agreed to surrender prior to the other officers employing less lethal force, and that therefore officers cannot claim self-defense. But as discussed before, even if that is true, that doesn't affect Officer Perez's ability to claim justifiable homicide, as there's been no evidence that he was involved in the use of less lethal force or the actions used to attempt to effectuate the arrest of Mr. Boyd. But more than that, there's been no evidence produced in the state's case that Mr. Boyd ever put down his knives and surrendered. In fact, the undisputed evidence is that Mr. Boyd still held his knives at the time he was shot, as they can be unmistakably observed on the video, not only being brandished just prior to being shot, but also still in his hands afterwards. Now, the law teaches us that in assessing the degree of threat that is facing an officer, the court should consider several factors, including whether the officers ordered the suspect to drop his weapon and the suspect's compliance with police commands, whether any hostile motions were made with a weapon towards the officers, the distance separating the officers from the suspect, and finally, the manifest intentions of the suspect. Now, that comes from another edged weapons case in which the court found that the use of deadly force was reasonable as a matter of law. That's the State of Larson v. Murr, 511 Fed 3rd 1255, which is a 10th Circuit case from 2008. That focus, again, is on what a defendant officer perceives to create a danger, not on the perspective or on the actions of others. Now, the state's burden in this proceeding is to demonstrate that it is reasonably probable that a crime was committed by the accused. It cannot escape its burden to demonstrate that Officer Perez's actions were not legally justified simply by questioning the actions of others. By law, the focus must be solely on Officer Perez's perspective at the time he made the decision to shoot. Now, the state's case is complete, and it's failed to come forward with sufficient evidence to demonstrate that it's reasonably probable that Officer Perez shot at James Boyd for any reason other than an objectively reasonable belief that Mr. Boyd posed a significant threat of death or serious bodily injury to a fellow officer. As such, it's failed to meet its burden on an essential element of each one of the charges, and Officer Perez respectfully moves the court to dismiss all charges against him at this time.
Thank you. Mr. Bregman?
Your Honor, I would join in everything counsel for Mr. Perez just stated. I would just have a few more things I'd like to mention on behalf of Officer Sandy. Mr. Sandy, he also asked you to dismiss this amended information against him. And Mantelli really, I think, dictates the law and helps us apply the facts in this case to the law. Specifically, it gives us the jury instruction that we're to be used in this, and obviously it says homicide is necessarily committed when a public officer or public employee has probable cause to believe he or another is threatened with serious harm or deadly force while performing those lawful duties described above. For there to be probable cause, the facts must be such as would warrant a belief by a reasonable officer based upon the expertise and experience of the officer. A reasonable officer, Your Honor, and it's the burden is on the state. The burden is on the state to say that they weren't reasonable. I have not heard any testimony that they weren't reasonable, these officers. Moreover, we have not heard any testimony at all about reasonableness. There has been nobody, not one witness, not one document that goes to the reasonableness of these officers. They show you a video and argue. With the utmost respect to Your Honor, you're not a police officer. You are a judge. You are a finder of fact. They have to provide you the ability to make the decision under Mantelli. They have given you nothing to do that. They have argued that this is 19 people there. They don't have 19 defendants sitting here. They argue that this is all created all the way back to the open space officers, who apparently were the aggressors, they say, and then want to attribute it later to Mr. Sandy. The evidence you have heard, though, is there's a layered approach following their training to try and take him into custody. And the important part that I guess they want to kind of ignore, but as this court well knows, they were obligated at that time to take him into custody. Obligated to take him into custody. So they came up with a less lethal force. So the question then becomes, was this justifiable for them at that moment in time? And they have provided you with not one shred of evidence when it comes to what a reasonable police officer does. Now, I will point out that there is this aiding and abetting theory that they went after Mr. Sandy on. Aiding and abetting means that, and the law is there, and we gave you a bench brief, Your Honor, that contains some of that law. It says that Mr. Sandy has to intend for Mr. Perez to kill him. Where was one witness, one shred of evidence, one CAD report, one police officer, one anybody that said they even spoke to each other before this took place? How in the world could Mr. Sandy intend that? They give you no evidence for that. I think it is interesting on the fact that the two eyewitnesses, the two people closest to the area, excluding the two defendants, Mr. Sandy and Mr. Perez, were Officer Weimerskirtz and Officer Ingram. They chose not to call them. But there's certainly no evidence that Mr. Sandy intended Mr. Perez to do something, much less shoot him. None. Where is that come from? There's no communication. How could he? So their aiding and abetting theory for which they've charged him under must fail. And where is the evidence that they've tendered based on this long-winded argument about him, their argument that he was surrendering Mr. Boyd? Where is that testimony? Where is that evidence when he has two knives out, when just because, and this may sound a little harsh, Your Honor, but just because you're crazy doesn't mean you don't have to, or delusional doesn't mean you don't have to abide by police officers' commands when they have...
Ms. Bregman, I'd like to object to Mr. Bregman continuing to call this man crazy. I think it's insulting and
delusional.
It's similar to what his client said about Mr. Boyd. So
Delusional. Can I continue?
Go ahead.
Delusional, to say the least. I think he's been described as that. But the fact of the matter is that where is the evidence to suggest that he was surrendering? And the point that I was making was, regardless of what's going on in your brain, regardless of your mental illness, regardless of the mental instability, it doesn't mean you don't have to obey police officers' commands. That's not the law. We don't make an exception for that. So where is this surrendering part when he drops the bags, just like as you heard from Keith Sandy's own words, dropping a hockey set of gloves and pulling out the knives, whether or not you want to call it a defensive posture or an offensive posture, when police officers are coming in to make that arrest, that's what he does. How is that surrendering? That's not surrendering. Surrendering is when 4 officers are yelling at you, get on the ground, get on the ground, get on the ground. You get on the ground and you drop the knives. That's surrendering. It's not dropping your backpacks and get in a fighting position with a couple of knives. That can't be surrendering, and nobody has said that a reasonable officer would perceive that as surrendering. To the contrary, they have introduced no evidence whatsoever to show that this was not justified. And the problem then becomes, Your Honor, is you're being asked to hold over someone based on what we know was the law with absolutely no facts to support it. And so I ask that you dismiss this amended information in its entirety when it comes to Mr. Sandy. Thank you, Your Honor.
Thank you. State?
Well, Your Honor, let me start with the evidence part of this. I know Your Honor has been the one assigned to do most of the preliminary hearings over the last several months. And I think you know you have more evidence in this case in a preliminary hearing than I expect you've ever had in any other case that you've heard. And the kind of evidence that usually you only get at trial that we've presented for this court. Let me start with the last thing in our brief, and that's why we provided you a complete trial brief, Judge, with the law that quoted the law that you can't start the fight and then claim self-defense. But let me start with the last thing, the last reason that we gave. When a victim is surrendering, doing what he was ordered to do, and is not an immediate threat, you cannot shoot him in the back. You cannot shoot him in the side. And that's the trope that APD always says when they shoot somebody, and what people in the public say, if you just followed the officer's orders. And what happened in this case is at the very end, Mr. Boyd, even though he kept expressing through the 2.5 hours that he was negotiating with them, I don't trust you because you're the ones who pulled a gun on me, you're going to hurt me, I don't trust you, at the very end said to them, I'm trusting you to keep your word. I'm trusting you to keep your word and I'm surrendering, and he picked up both of his bags. And I'll ask you to watch the tape, Judge, which is the best evidence, which is why you don't need expert testimony if you've got a videotape. And Mr. Bregman's implication that civilians shouldn't judge the conduct of an officer is anti-American. I mean, that's the whole system. If you're going to take somebody's life, then you can, no matter who you are, whether you're a police officer or a civilian, you get to be brought to court to be judged by reasonable people and not necessarily police officers. That's not the standard. So what he did was not throw down his bags, as was described, but he drops them when they hit him with the flashbang, and he doesn't pull out his knives until they tase him and then sick the dog on him, and it's after the dog runs up to him and he puts his hand out that he pulls out his knives, perhaps to respond to the dog attack on him. But the key thing, why didn't he do what they said? He did what they said, and his last words were, I'm trusting you to keep your word. And as soon as he took a step, they flashbanged him and tased him and sicked a dog on him. And then he did what they said again, because after he pulled out the knives in a defensive posture, Officer Sandy's own words, not ours, they said, get on the ground, and he turned to get on the ground and follow their instructions. And when he was following their instructions a second time that they shot him. 2 shots in the side and 1 in the back, and Officer Sandy's own testimony says, I knew he was turning away from us before I shot him. As far as justification in self-defense, the law requires that the defense come forward first and make a proximate cause argument, or make some argument of self-defense. Because you have no statement from Officer Pettis, you don't know why he shot him. There is no evidence that's been presented by the defense of self-defense in this case, from Officer Pettis' own mouth, or that he was in fear or anything like that. And so that has to come forward first before the state then has to prove that this wasn't in self-defense by probable cause. The probable cause standard is a very low one, Your Honor. You have all the evidence you need for all of these things. One more thing I want to address is the aiding and abetting. We charge that in the alternative, aiding and abetting or homicide. The evidence that's been presented, I think, on the cross-examination by Mr. Bregman was that the Office of the Medical Investigator said the cause of death was not the bullet in the back, it was all of these gunshots combined. And so they combined to kill this man because of the blood loss, and there is a direct charge against Officer Sandy of homicide as well. Thank you, Judge.
Counsel, we've quoted and several times and cited the Mantelli case, and we've thrown the term reasonable police officer out there, but my understanding, it's the reasonableness of the police officer's actions that is the objective standard that the court looks at. I'm sure that there are many reasonable people on this planet who do unreasonable things. So my understanding of the law is that we look at the police officer's actions and determine whether those are reasonable and whether a reasonable police officer would have acted in that form or fashion. If I could ask you, Ms. McGinn, when I looked at the amended informations, could you address, or please, you charged the lesser included offense of involuntary manslaughter, and I'd like to give you an opportunity because I have some doubts about that particular offense being charged, since the evidence, what I've heard is more of intentional, and I haven't heard much of anything unintentional.
Right, Judge. Let me tell you my thinking about it. It was that certainly for Officer Sandy, who says I made the decision in his statement, I made the decision to shoot him based on the proximity of the officer and the knives, that I think that is intentional for Officer Sandy. As far as Officer Pettis, you have no testimony about his state of mind. My thinking in it was that Officer Pettis rushed into this situation without knowing fully what was happening on the ground. I disagree with the comment that he wasn't involved in this at all, because on the tape, the person who says, do it, to throw the flashbang, is Officer Pettis. It's the loudest voice, it's the person with the helmet cam, and he's the one that says, do it, and so sort of participates in all of this as well. But my thinking was that it was his sort of, it seemed more like negligence to me, or like criminal recklessness, to rush up there without finding out what was going on, without talking to somebody, without following the rules. That's my thinking on it. But as I told you before we ever started this, Judge, in truth, if they decided to shoot him thinking they were acting in self-defense, it is more like a voluntary or second-degree charge. That's really what it is. If that was their intent and it's imperfect self-defense, it's one of those two charges, and it's an intentional act rather than a negligence act. So I understand the court's thinking about that, and I will leave it to the court to decide whether to go forward with the involuntary charge or not.
Well, let me just first start off and say that with respect to the lesser included offense of involuntary manslaughter with respect to both defendants, I fail to see the evidence to substantiate those charges. So the court is going to dismiss the involuntary manslaughter on both amended informations as to both defendants. With respect to the remaining charges, the second-degree murder, lesser included offense of voluntary manslaughter, the aggravated battery, the aggravated assault, I'm going to deny the motion to dismiss those at this point in time. Is the defense ready to present any evidence, if you wish?
Yes. Your Honor, defense calls Alexander Dixon.
And Your Honor, if you'd switch it over to the podium, please, for the VGA.
Okay.
I believe. Thank you.
Sir, would you raise your right hand for me, please? Do you swear or affirm under the penalty of law the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. Please be seated.
Good afternoon, Mr. Thixton. How are you currently employed?
I'm with the United States Air Force. I'm a captain and an aerospace engineer.
And when did you first join the United States Air Force?
It would have been May of 2005.
And prior to joining the United States Air Force, did you pursue any post-secondary education?
Do you mean?
Any college, undergrad, graduate?
Yes, a bachelor's in aerospace engineering.
Okay, and where did you receive that degree from?
Embry-Riddle Aeronautical University.
And during your time in the United States Air Force, what ranks have you held?
Second lieutenant, first lieutenant, and now captain.
And as a captain, briefly, please describe your duties and responsibilities.
Currently, I'm the Deputy Branch Chief for the Spacecraft Component Technology Division. We work on satellite technologies such as solar panels, communication equipment, and structural systems.
Is it fair to say you're very familiar with technology?
Yes, sir.
Now, during your time in the United States Air Force, where have you been stationed?
My first assignment was Wright-Patterson Air Force Base in Dayton, Ohio. After that, it was Los Angeles Air Force Base. I went to Al Udeid Air Base in Doha, Qatar, and now where I'm presently assigned is Kirtland Air Force Base, New Mexico.
And when were you first assigned or stationed at Kirtland Air Force Base?
Late January of last year.
And did you move to Albuquerque when you were stationed at Kirtland in late January last year?
Yes.
And when you say last year, you're referring to 2014?
Correct.
Now, after moving to Albuquerque, did you live on or off base?
I lived off base.
And what area of Albuquerque did you live in?
It's in the foothills east of Tramway.
When you say in the foothills, near the foothills, is that fair?
Correct.
And what was the address of the residence you moved into?
812 Piedra Vista Road Northeast.
Now, from your house, you mentioned it backed up to the foothills. Do you have access to the foothills?
Yes.
And how do you access the foothills from your house?
There's a gate in the backyard.
And do you use that gate often to access the foothills?
Yes.
And once in the foothills, what do you do?
Once I'm in the foothills, there's some hiking paths back there. There's mountain trails. It picks up to a number of trails back in the area.
And then, do you spend much time in the foothills behind your house?
Yes.
And are you familiar with the terrain in the foothills behind your house?
Yes, mostly.
If you would, please explain the general nature of the terrain behind your house.
So you have a couple of footpaths. They're dirt paths. We have U-mound behind our house, which is a steep slope. It's a steep mound. We also have cactus, brush, loose rocks, things of that nature.
So you mentioned a steep mound behind your house.
Yes, sir.
Where does that steep mound begin behind your house?
I'd say about 100 yards away from my backyard.
And if you could, please describe how steep that mound is.
It's probably about 30 to 40 degrees elevation. It's I guess steep would be the word for it.
Okay. Now, since you moved into your house at 1812 Piedra Vista, have you had any problems with individuals causing disturbances in that foothill area?
Yes.
And please tell me what disturbances you've experienced in that foothill area.
Objection, relevance, Your Honor?
Counsel, tell me the relevance, please.
Your Honor, we've throughout this proceeding, we've talked about individuals camping, well, Mr. Boyd camping back there as if it was an area where individuals commonly camp. So I'm just laying a foundation as to getting into whether individuals commonly camp back there.
I'm going to sustain the objection, ask that you move on, please.
Now, did there come a time when you noticed that an individual was living in the foothills behind your house?
Yes.
And as we are here today, do you currently know who that individual was?
Currently, yes.
And who is that
That
individual?
would be James Boyd.
When was the first time you noticed that Mr. Boyd was living behind your house in the foothills?
It was February 27th at 1 a.m. And if you'd like, I can go into some background.
Yeah, please describe why you noticed he was living in the foothills at that time.
Sure. My dogs were barking late at night. I told them to hush. They didn't listen, which was unusual, so I went outside in the backyard. I grabbed the dogs and pulled them in, and I heard yelling from the mountains. It appeared that there were two individuals in that area. One was yelling at the other. I could hear conversation back and forth. I listened for a while. The yelling turned hostile. He said he was going to harm the other person. He made a lot of threats, so that's when I called the police.
And when you say he, who are you referring to?
I now know that person to be James Boyd.
And how do you know that individual was James Boyd?
I recognize the voice and the hostility in his voice.
And you said that he threatened to kill another individual.
Yes.
Were you able to see that individual?
Not until later.
And when you saw that individual later, what was his appearance like?
So the other individual who was with James Boyd, it was a younger black kid, probably in his late teens or early 20s. And it looked like he had a shaved head.
Now, how did you react when you heard that verbal altercation occurring in the mountains?
It was scary.
Now, why do you say it was scary?
When you hear something like that coming from the night in your backyard, it's terrifying to have that so close to where your family lives.
And what did you do after you heard that altercation taking place?
I called the police.
And did the police respond?
The police at the time did not go up to the area. I was informed later that they drove down Piedra Vista. I'm not aware of any attempt made to go up there.
Now, was that the only time you called the police on Mr. Boyd?
No.
How many other times did you call the police on Mr. Boyd?
There was one other back in March 16th. That wasn't the only time I had identified Mr. Boyd.
Okay. And we'll move into that incident shortly. But before we get to that incident, were there any other disturbances you noticed behind your house after the February 27th incident?
Yes, on March 1st, my wife was taking a shower, and we have a window in our bathroom. She could see early in the morning someone changing clothing behind the rocks.
And when you say someone, who are you referring to?
That'd be James Boyd.
Now, how did your wife react? Without telling me anything she said, how did your wife react to seeing Mr. Boyd behind your house while she was in the shower?
Objection, relevance, Your Honor.
Sustained, Mr. Rowe.
After your wife informed you that Mr. Boyd was behind your house while she was taking a shower, how did you react to that?
I took out my camera and I took a couple of photos. It was very suspicious.
Now, why do you say it was suspicious?
Having an individual living, in that open space area back there, changing, kind of alarming to my wife when she saw that. And of course, put two and two together, that was the guy who days prior was threatening another guy up in the mountains.
Now, to address the concerns you had regarding Mr. Boyd's presence in the foothills, besides, well, in addition to taking the pictures, did you take any other steps?
Prior to March 16th?
Mm-hmm. Yes?
Not at that time.
Okay. Now I'd like to talk to you about the events that took place on March 16th, 2014. Now, please describe the event or series of events that led you to call police on March 16th, 2014.
Sure. So on March 16th, I hiked up U Mound, the mound I described behind my house. And while I was up there, I was looking down. I could see behind that rock shelf. And there was a clear plastic tarp, and it looked like some belongings down there.
And where were you located on U Mound when you noticed that clear plastic tarp?
I was on the top of U Mound at that time.
Prior to seeing that tarp with belongings under it from the top of U Mound, had you seen that tarp with the belongings under it?
No.
Were you able to see that tarp from your house?
No.
Why not?
It was behind rocks. The rocks kind of form a shelf about probably 3 feet high or waist high that kept it discreet from our house.
Okay. Now, after noticing the tarp and the belongings below you on U Mound, did you approach the belongings?
After I noticed it, yes, I did approach the belongings.
Okay, and why did you approach the belongings?
We have a neighborhood association that has reported theft in the area, and I wanted to see if there was any stolen property there or any weapons.
And did you touch any of the belongings or the tarp that were located on U Mound?
No.
Why not?
I didn't want to go into it. I didn't think it was within my rights or responsibilities to do so, to touch someone else's belongings.
Now, how long did you remain in the area of those belongings?
I'd say I was probably around there for 15 minutes.
Now, I'm going to hand you what has been marked for identification purposes as Defendant Officer Perez's Exhibit E25. Can you please explain what I've just handed you?
So this is debris, or I'm sorry, this is his belongings, the clear plastic tarp, backpack and clothing, and other items behind the rock shelf that I saw.
And is that, well, I should ask, did you take that photograph?
Yes.
And is that a fair and accurate depiction of the items you photographed?
Yes.
Your Honor, I move to admit Defendant Officer Perez's Exhibit E25.
No objection, Your Honor.
E25 will be admitted.
I'm going to pull that photograph up for you on the screen and you'll see it next to you. So now that everyone can see this photograph, please explain what can be seen in this photograph.
So he has multiple book bags.
Not to interrupt you, but you can actually touch the screen and draw on it if you would.
Okay, sure. So there's multiple book bags, there's clothing, there are cloth bags with stuff, food items, of course the clear plastic tarp, and just other miscellaneous things.
Is that how those items appeared when you walked towards them?
Yes.
And you didn't disrupt or touch any of the items?
No.
Now, is your house captured in this photograph?
Yes.
Will you please circle your house? Now, is it fair to say that your house has a balcony on it, essentially?
Yes.
Now, do you see any individuals located in this picture?
There are 2 hikers on Copper Trail.
Is it common for people to hike back there?
Yes.
Now, after you noticed these belongings, what did you do?
After I noticed these belongings, I called, it was a non-emergency police line.
And why did you call? Well, before we move on, when you were up at this campsite, were you with anyone?
No, not, it was just myself, and later I had gone down and grabbed my 2 dogs, and I have a concealed carry permit, so I grabbed my pistol for self-defense and went back up to the site.
Okay, let's talk about all of that. So you were on U-Mound, correct, when you saw this site the first time?
Correct.
And what did you do after you saw it initially?
After I saw it initially, I went down to the house, I grabbed my 2 dogs, and I grabbed my pistol, which I concealed.
And why did you grab your 2 dogs?
For self-defense.
And what kind of dogs are those?
They're Great Danes.
And why did you get your sidearm?
Again, for self-defense.
And what kind of sidearm is that?
It's a small pistol.
And at the time of this incident, did you have your concealed carry permit?
Yes.
And why did you feel that it was necessary to arm yourself before returning to the camp?
Because
Well, I think he's already answered the question. He testified he had it for self-defense, so I'm going to ask you to move on.
Yes, Your Honor. Now, did there come a time when you returned home after you noticed this camp?
yes,
And what did you do when you returned home?
I returned home. That's when I called it was the police non-emergency line.
And why did you call the police non-emergency line?
He wasn't present at the time, and he wasn't, the time before I called 911 because he was hostile. This time, I just discovered that his belongings were back there, so I called the police non-emergency line. I didn't feel it warranted urgency at that time.
And after calling the police non-emergency line, what did you do?
After that, I believe I just, went to the balcony and looked out the balcony and just waited for the police to arrive.
Okay. And what did you see when you looked out the balcony?
So eventually, I saw James Boyd return to the campsite.
And when you say you saw him return, what specifically did you see?
I saw him return to the spot where I just was, and I think he was like settling in. Like he was putting his bag down.
When you say settling in, what do you mean?
Like he was living there.
After noticing that James Boyd had returned to his camp, what did you do?
So I called the same number I called before, and I told them that he was back at the site.
Now, did there come a time when officers responded?
Yes.
And where did those officers respond to?
So they initially came up to my front door.
And how many officers came up to your front door?
2 of them.
Now, will you please describe the appearance of the 2 officers who came to your front door?
They were in full uniform.
When you say full uniform, what do you mean?
They had the black police uniforms, badges, full attire. They had their belts with all of their equipment.
Did you have any doubt that they were police officers?
No.
Now, without telling me what you said or what the officers said, did you speak with the officers?
Yes.
Please describe their demeanor at the time they arrived at your front door.
They were professional.
When you say professional, what do you mean?
They listened to what I had to say. They asked, or I guess they informed me that they were going to approach from Copper Avenue rather than approach from my backyard, because that way James Boyd would not associate the caller or whoever called that he was there.
Now, how did the officer, well, if you know, did you tell the officers where James Boyd was located?
Yes.
Did you show them where James Boyd was located?
Yes, I took them upstairs, and from the balcony I pointed to where he was. I described to them how to get there.
And was he at his campsite when you pointed out where he was camping?
Yes.
Now, after you pointed out where Mr. Boyd was located, what occurred?
So the two open space officers went down to Copper Avenue, and they walked up Copper Trail, the foot trail. They went off the trail and climbed up to where James Boyd was camping at.
Okay, and were you able to see the officers walk up the trail?
Yes.
Did you notice them doing anything to conceal their presence in the foothills?
No.
And were they, as they walked up the trail, were they still wearing their uniforms?
Yes.
Now, as you watched the officers walk up the trail towards James Boyd, what were you doing?
I was on my balcony just watching, and I had my camera.
Now, when you say you had your camera, what do you mean? What kind of camera?
So I had a point-and-shoot camera that's designed for video. It has a 20 times optical zoom, and it records in full HD. And I also had my cell phone camera, which was off my iPhone.
Okay. And why did you have both? And what type of camera was the first one you described?
The first one was a Canon SX280 camera.
And why did you have your Canon and your iPhone while you were sitting on the balcony?
I guess I thought it might come in handy if needed.
When you say come in handy, what do you mean?
If, I guess it would be hard to describe, but, you know, I wanted to video the encounter just in case anything were to happen. If he were to not cooperate, it would provide good evidence of what events occurred.
Okay. And was there anything that obstructed your view of Mr. Boyd's location from your position on the balcony?
Yes. So this shelf, it in parts extends about 1 foot high, and other parts it's up to about 2 or 3 feet high. So when the officers initially approached James Boyd, I think he was either sitting or laying down. I could not see him.
Okay. And what specifically, again, prevented you from seeing Mr. Boyd?
It would be the rocks and the brush in front.
Now, during this incident, did you use your iPhone and your camera to record parts of the incident?
Yes.
Why did you use both devices to record this incident?
My camera could only record video for about 20 minutes or so before I'd have to recharge the battery. So the camera was the better device for recording, so, but I wanted to record in between, so I'd pull out my iPhone and record when I could with my iPhone while the Canon camera was charging.
So while the Canon was charging, you would film with your iPhone?
Correct.
Is there any difference in between the quality of the video taken by your Canon and the quality of your iPhone video?
Yes, there's quite a few differences. So the Canon camera has a slightly larger sensor. It has an optical zoom, which means rather than digitally blowing up a picture, it can actually magnify into a subject that you're looking at. It has optical image stabilization, so you don't have handshake, and it best accurately reflects the lighting conditions.
And why is your Canon better equipped to accurately reflect lighting conditions than your iPhone?
Because the iPhone and small devices will tend to bump up the ISO, that's the sensor sensitivity, to try to brighten the picture. And so the Canon, it doesn't do that unless you manually change the exposure. It'll just leave the exposure accurately representing what the lighting conditions are.
Now, did you videotape the entire March 16th, 2014 incident?
Only parts of it. I believe I have about just over an hour of the 3-hour altercation.
And why did you only videotape parts of this incident?
It was a very long standoff. There were times when it just didn't grab my attention at that time. And there were other times when later he would go on yelling and threatening, and that warranted my attention, so I'd bring out the camera to film then.
Is it fair to say that you videotaped the portions of this incident you were interested in?
Objection.
Yes.
Reading, Your Honor.
Sustained.
Now, you said it was quite a lengthy incident. How long did this incident last?
About 3 hours, if not a little longer.
Now, when you were videotaping this incident, well, first, have you reviewed the videotape that you took that day?
Yes.
Did that videotape accurately depict all the sound, or did the video pick up the sounds you were hearing?
Sometimes it did. If James Boyd was loud enough, you could hear what he was saying.
And did it pick up everything that was said?
No.
Now, after the incident was over, did you leave the video footage you captured on your iPhone and your Canon camera?
Yes.
Did you transfer that video footage to any other device?
I did copy it onto my personal computer.
And why did you copy the video onto your personal computer?
So I could review it at a later time.
Did you provide the video to anyone?
Yes.
Who did you provide it to?
I provided to the Albuquerque Police, and I believe there was also, at a later time, the FBI Civil Rights Bureau.
And after you transferred the videos to your computer from your iPhone and Canon camera, did you review the videos?
Yes.
And did that, once they were on your computer, did they still accurately represent what you videotaped that day?
Yes.
Now, did you make any enhancements to these videos?
No.
Did you make any edits to the videos?
Yes.
Now, please explain what you understand editing to mean.
Correct. So what I did with the videos was I wanted to put them all together as a timeline. And to do that, you have to bring it into a video editing program where you can take the clips and place them next to each other. I also felt what would be relevant would be to have the times that the video was taken, and I could get that from the file information that was on the videos. And I also thought the camera that was used was relevant. Since my Canon camera could not record for a lengthy period of time, I had to go back and forth between the Canon and the iPhone. I put which camera was actually recording.
Okay, now you mentioned that you wanted to create a timeline.
Correct.
Why did you think it would be helpful to create a timeline?
Because otherwise you have multiple videos as separate files that you'd have to open up separately. And I think unless you can watch a situation from beginning to end, you don't get a good feel for what exactly is going on.
And did you leave any video out of this timeline that you created?
No.
So you included all of the video you took in this timeline?
Yes.
Now, you also mentioned that you placed times on this video, correct?
Correct.
How did you place those times on the video?
What I did was when you copy the files onto the computer, you can click and get information off when that video was actually recorded. And so what I do is I just look at those individual files and mark down the times, and I would put it as as text over the video for the final timeline that I made.
And did that process of adding the times to the video change the contents of the video you took?
No.
Now, you also mentioned that you included the type of camera that was taking the video.
Correct.
Why did you decide to do that?
Towards the end of the video, as it gets darker, as I had mentioned earlier, the iPhone and mobile cameras try to increase the ISO sensitivity, try to brighten the video. The Canon doesn't do that unless you manually tell it so. So I'd have one video that appeared dark, which was accurate of what it was as it got into dusk. Another where it appeared a little brighter. And to avoid confusion, I wanted to put what camera was used so that the viewer could see that the reason there was a difference in brightness from one to the next is because of the type of the camera that was used.
And did the process of adding the type of camera to the video, did that change the video in any way?
No, that was just adding text over the bottom portion of the video, similar to the timestamps.
Now, did you review the videos both before and after you added that text?
Yes.
Did adding that text change the video at all?
No.
Now I'd like to show you some clips from your video which has been previously admitted as Defendant Officer Perez's Exhibit B4. Now if you'll tap the lower left screen, the lower left corner, I'm sorry,
Lower
it
left
should
corner.
clear the screen.
Okay.
Sweetheart. It's got a knife.
Your Honor, I'm going to object on any, if you can stop it just for a second. The one thing that I would object to is the sound portion of all of this and his running commentary as he's watching this and what he's saying to his wife. I think that is hearsay. Even if he's in court, it is an out-of-court statement by a declarant that was out of court at the time, not just that. His wife begins to comment too, and she's not here for cross-examination.
Response.
Your Honor, first and foremost, this has been admitted into evidence, and therefore it's not an out-of-court statement. It's been accepted into evidence. Moreover, all of the statements that are made on this video fall within hearsay exceptions. Primarily, 11-8031, present sense impression. He's simply describing what he's observing while videotaping this. And also his wife's 803 does not require that the declarant be available as a witness. So although his wife does make statements and she's not here, that does not bar it from still coming in under the present sense impression exception.
I think it is already in evidence, to be honest.
And that's the other thing I want to raise, Judge. If you'll recall how this came in, they came up and said, well, you've had this, and we'll give it to you. And it wasn't until we looked at it at night that we realized there was this running commentary by the person filming it. And when they first played it to the court, if you'll recall, the excerpts they played did not have any sound on it. And I would ask that if this is going to be played, that it be played without the sound.
Well, I seem to recall that when I initially watched the video, there was no sound, and I assumed that's the way it was. My question to you is, and I know that the state has raised the issue of hearsay, and you said, well, it's part of the video, and it came in that way. What is the relevance for the court to listen to commentary while the video is being played when you have the witness right here who can, if you have any questions, he can explain?
Well, Your Honor, while this was taking place, Mr. Thixton was describing what was happening as it was happening, and therefore it is a present sense impression. So that instead of simply him trying to remember what he said at that exact time, by providing him with the video that he created and the comments he was making as it was happening, it provides an accurate...
But counsel, my question is, how are his comments going to be relevant to me in deciding the case that are on here.
Well, Your Honor, because several things that are said by Mr. Boyd simply cannot be heard on the videotape. But Mr. Thixton, as he was there, could hear what was happening.
That's even more troubling, Judge. That he's saying what he's saying as opposed to you actually hearing what Mr. Boyd is saying. It's coming through his interpretation rather than what Mr. Boyd is actually saying.
I'm going to allow you to play it without the sound because that's the way it initially came in, and that's the way I understood. I thought it was no sound exhibit, but certainly if you need to stop it and ask your witness what's taking place at this point in time, I'll allow you to do that.
And if I may, Your Honor, this video was played for Jeff Stone by the state with the sound yesterday morning.
I don't recall that. I don't recall the sound. With the commentary, I thought there was sound on it, but I didn't know there was commentary.
Right, Judge, we edited out the commentary. We edited out the commentary on purpose because it's hearsay and kept in the ambient sound, the sound that you can hear in the background. And that can be done. The objection is to the commentary, not what Mr. Boyd was saying.
Well, that's what I'm concerned. I never heard any commentary when I initially heard it. So that'll be my ruling. If you want to proceed that way, you certainly can.
Okay. Thank you, Your Honor. Now I'm going to begin this clip again, but there won't be sound. Do you understand that?
Yes.
Now, what did you observe in that video clip that I've just played for you?
So the two police officers had approached James Boyd, and they drew their pistols and stepped back, and they said, "Drop the knife, drop the knife." And then I saw James Boyd stand up and slope looking at them. I'm assuming he had a knife on him since that's what the officers said.
And what did James Boyd do after he stood up in this video we saw?
Afterwards, he slowly approaches the officers.
And how did the officers react?
The officers stepped further back and kept their guns pointed on him.
Now I'm going to play a second clip for you, and we'll see if it's meaningful without the words. Now, what did you see the officers doing in that video?
I saw them further taking steps back from James Boyd.
And based on your observations that day, why were the officers taking steps back?
Objection, Your Honor. He's asking him to decide why the officers were doing what they were doing. And that's improper.
I'll rephrase.
Okay.
As those officers were taking steps back, did you observe what James Boyd was doing?
Not from the video. I would assume he was approaching them.
Again, objection, Your Honor, if he's going to assume anything.
Sustained.
Now, during this incident, as you were videotaping it, did you hear James Boyd make any threats towards officers?
Yes.
What threats did you hear him make?
He said he was going to kill them if they approached him.
And did that cause you any concern?
Yes.
What concerns did that cause you?
Objection, relevance, Your Honor.
Counsel, what's the relevance of that?
Your Honor, there's been some indication by the state that these officers simply could have left this situation or given him more room and left him alone to be camping. And certainly it's relevant. This is a citizen who lives nearby who would have had great concern if they had simply left.
I'm going to find that it's irrelevant as to what his concern was or how he felt about it.
Now I'm going to play another clip for you, Mr. Thixton. Now, what occurred in the clip that I just showed you?
So in that clip, while I was filming James Boyd, I saw a woman jogging right down Copper Trail, and I believe I said she has no idea what's going on.
Objection, Your Honor. He's now saying that you're saying that was excluded from the tape.
I'll allow the answer to stand over.
So please, yeah, when you saw the woman, what did you say into the camera?
I said she had no idea what was going on.
And what was it about the woman's demeanor that indicated she had no idea of what was going on?
Objection, speculation, Your Honor.
I believe it's a proper lay opinion based upon his perception. That's allowed to answer the question.
She was jogging right by, just carrying about her jog, while a man had knives pulled against two police officers who had their weapons drawn on him. And she had no idea of their presence at all.
I'm going to play another clip for you, Mr. Thixton. Now, in the clip that I've just showed you, did you see anything in Mr. Boyd's hands?
Yes, I've reviewed this clip quite a few times. He had knives in both of his hands.
And when he had those knives, what did Mr. Boyd do?
He started slowly approaching the officers.
And did you observe how the officers reacted?
Whenever he approached, they would slightly raise their weapons toward him.
And how did Boyd react to that, if you observed it?
He was aggressive. He would sometimes step further, and he was yelling at them.
I'm going to play another brief clip for you. What occurred in that clip, Mr. Thixton?
There's a lot of hikers in this area, and those were 3 children climbing down from the top of the mountain to get a closer view of what was going on.
And were you able to observe their faces at the time?
Yes.
Were you able to observe their body language?
It looked like they were curious and they wanted to see what was happening.
Objection, Your Honor. I think that's speculation.
I'll allow the answer to stand. I believe it's a proper lay opinion.
And based on your observations, did you think those children knew what was occurring below them?
Objection.
Probably not.
Speculation, Your Honor.
I think that one called for speculation will sustain the objection.
Going to play another clip for you, Mr. Thixton. Now, what time was that clip taken?
7:24 p.m.
And how long, approximately, had the incident been going on at that time?
About 2.5 hours.
And what device did you use to take the video that we just saw in that clip?
I was recording with the iPhone.
And did your iPhone accurately represent the natural lighting that was present at that time?
It slightly brightens it.
Please describe the natural lighting at 7:24 on March 16th, if you can remember it.
From what I've seen from the video, and at the time I remember it to be accurate, was that the Canon video was starting to get darker because that was accurately representing what the proper exposure was at that time. That it, the Canon, when it gets darker, it shows it is darker. With the iPhone, it tries to brighten it, so the picture comes out better, so you can see what's going on.
I'm going to play another clip for you, Mr. Thixton. And what time was that clip taken?
That was, I didn't take a close look, but I think it was 7:26 p.m.
Would you like to see it again to be sure?
Yes, please.
Now, can you please describe what you've just seen in the clip I played for you?
Sure. So I see James Boyd putting on it was a loose hoodie, a sweatshirt.
Now, before James Boyd put on that sweatshirt, had you noticed what he was wearing?
I know he was wearing it was like a button shirt that was unbuttoned. I think he also had a shirt underneath that.
And did he take either of those shirts off before he put on the sweatshirt?
No.
If you can recall, do you remember any significant temperature change at 7:30 on March 16th?
There was no significant temperature change. The temperature dropped by a little bit, but it wasn't cold.
And if you would, please describe what the temperature was like that night.
I think I was just wearing like a polo shirt that day and jeans. I can't recall exactly what the temperature was, but it wasn't frigid.
I'm going to play another clip for you. Now, what time was that clip taken?
I apologize again. I didn't look at the timestamp.
I'll go ahead
I'm
and
sorry
play the
for that.
first part again so
Okay.
we can...
I'll stipulate it was 7:27 is what it said, Judge, at the beginning of it.
Thank you.
That'll speed things up.
So it was 7:27 when you took that clip.
Correct.
And what did you take that clip with?
That was with the iPhone.
And please describe what you saw James Boyd doing in the clip that I've just played for you.
He appeared to be gathering his stuff, like he was going to leave.
And what did he do with his stuff after he gathered it?
I think he brought it with him.
And did he keep that stuff on his person
Yes,
throughout that clip?
I think so. I'd probably have to rewatch.
Would it help you if you rewatched it?
Yes.
Judge, I think this is in evidence so the court can watch it. I don't think we have to have to narrate what's going on here.
I'll let you play. Go ahead.
Now, what did that help refresh your recollection?
Yes.
And what did James Boyd do with the items he was holding?
So he picked up his backpack and then he approached the officers as if he was going to leave, and then he put the backpack down and it appeared as if he was going through items.
Okay. Play another clip for you, Mr. Thixton. Can you please explain what was shown in the clip I've just shown you?
That was two more officers going up towards James Boyd through my backyard.
And what time was that clip filmed?
7:25 p.m.
And as we sit here today, do you know who the officer was who had just arrived?
Yes, it was.
Objection, Your Honor. Hearsay.
I'll allow him to answer the question.
Yes, one of them was Dominic Perez.
Now I'm going to play the last clip I will play for you. Now, Mr. Thixton, in the first clip I played, what was that filmed with?
The first clip was filmed with the iPhone.
And did it accurately represent the lighting at that time?
No, it was slightly brightened. In fact, even though it looked bright, you could still see them using flashlights. One of them had night vision goggles on top of their head.
And now, this clip that I've paused it on, what was this filmed with?
This is filmed with the Canon camera.
And does that accurately represent the lighting that was present at that time?
Yes.
May I have a moment, Your Honor?
Yes.
Pass the witness, Your Honor.
Well, counsel, it's almost 5 o'clock. I think we should call it a day. We'll start the end of testimony at 8:30 tomorrow morning. What I will do is allow Mr. Bregman to, if he has any questions of this witness, then I'll give the state
their opportunity to ask questions.
All right, Judge, and before you leave the bench, we have our Daubert motion for the court.
Okay.
Courtesy copy. Courtesy copy.
All right. Anything else from either side?
Nothing from the stage, Your Honor.
Okay. And sir, I'd ask that you please be back at 8:30 tomorrow morning. I'd also ask that you not discuss the case with anyone until called back in the morning, okay?
Yes, Your Honor.
All right, thank you, counsel. Have a good evening. We'll see you tomorrow morning at 8:30.